So I'm really happy that some of the participants have kept their camera switched on. So that helps a really lot to present anything. So whoever, like for other participants, I request wherever it is possible to keep camera on, then please keep it on. Today's topic is on the MSME, and it's very as such a subject, there is not too many sections to cover up, and there are not too many judgments. So I request all of you to pose your queries as on when it arises in your mind, irrespective of to defer it. It will keep the session interactive and it will help us to understand the issue more better. So to start with, the concept of the MSME, basically it was long pending, but an act came in 2006. This act tries to give various benefits to MSMEs. So before going to the provisions of the IBC, I would like to take you through the provisions of the MSME Act, because that will make many of the things very crystal clear, that why this act was enacted, what are the beneficial provisions, and how the government tries to give benefit under the act to the various companies and other organizations. So the word MSME is used as industries and etc. establishments, and the company word is not as such there. So I'll just open on my screen the act, which is the MSME Act. Let me open it. Yes. So I'm sure you must be able to see the act. Could anybody confirm yes and no?
Yes.
Yes, it is visible.
Thank you very much. So if any of you have questions, you can also put it in the chat box. This act was enacted in 2006. And what is the objective is given in the preamble of the act. Basically, unlike other acts like IBC and etc., where a certain procedure is prescribed, this is a kind of beneficial legislation, something like Consumer Protection Act, which tries to give benefit to a particular segment of the society. Here, that particular segment is MSME. So what it does is, the act to provide facilitation, promotion, development, just a second, I'll move it here. Yeah. So the act to provide facilitation, the promotion and development and enhancing the competitiveness of the micro, small, medium enterprises and matters connected therewith. So there are three types of organizations: micro, small, and medium. As far as IBC is concerned, they do not make any distinction between these three types of the thing. They are only limited to the MSME Act. So for IBC, all the enterprises which falls in the category of the MSME gets the benefit of IBC wherever it is applicable. So where a declaration of, so there was a declaration as to the expediency and the control of certain industries by the union was made under Section 2 of the Industrial Development Regulation Act. So for facilitation and promotion, this particular act was enacted. Section 1 is not that important. Section 2, few of the things are important. First is the buyer. The entire definition surrounds around the buyer. And even in the IBC, basically, the significance is primarily on two things. One, when the CD is an MSME or the claimant is an MSME. So when the CD is MSME, what could happen? And when the claimant is MSME, what could happen? So when the CD, we will go to the 29AN exemptions. And when the claimant, what happens? The buyers are normally OCs, most of them are operational creditors are buyers, means whoever buys any goods or receives any services from the supplier for consideration. This is the first definition. So anybody, very simple things. Then the next definition is enterprises. So MSME is basically going by the definition of the enterprises. Enterprises means industrial undertaking or business concern of any other establishment, whatever by the name it is called. And there is a first schedule. Now, if we go to the website of the MSME, Udyam registration, then they have clearly created the segmentation. And in this segmentation, they have specifically defined what is there, what is not there, and the limits is also increased. So now I think 250 crores, everything can come under the MSME Act. And even the process of registration has made really simple. So if you have the simply KYC norm, the entire process is online, and the registration also gets generated sometimes within a day or two. So this is the enterprises on which this thing is applicable. So one has to be a buyer. Second, what is being sold and what is goods and services. So earlier there was some doubts regarding the services. Now both are included. So one of the definition is goods means every kind of movable property other than the actionable claims and money. So movable property definition normally takes its effect from the Transfer of Property Act, where almost everything which is not attached to earth is considered movable. However, actionable claims and money is not. So money, everybody knows it's hard currency or a soft currency as of today. 1, 2, actionable claims. So what are the actionable claims? All the IBC professionals are really familiar with the concept called not readily realizable assets. Those squarely falls within the definition of the actionable claims. Where you have a claim, you can take action of the claim to realize that claim is normally the actionable claim. It is a layman's oversimplification of the entire concept. Otherwise, there is a technical definition which has been provided in the Transfer of Property Act. But in the simplest term, actionable claim are, I repeat it again for the benefit of the all of you, that if law permits you to initiate an action to realize a particular claim, then it is an actionable claim. It is as simple as that. So this is the actionable claim. So what is so special about the actionable claim? So actionable claims are transferable by law. Law allows them to transfer the claim from one party to another party. Therefore, they are actionable, they are transferred, they can be purchased and sold in the market. But this particular act cannot be used to realize those claims because it gives benefit only to the enterprises who are as such registered, and third party cannot claim that benefit. Or the MSME cannot buy those claims and take advantage of the provisions of this act. And therefore, for this specific reason, these particular actionable claims have been kept out of the purview of the MSME Act. Then the medium enterprises, nationalized banks. Then there is a definition of suppliers. Supplier means micro, small enterprises which has been filed a memorandum of authority referred under so and so in section so and so. So as far as this concept of filing of the memorandum is concerned, when the act originally was enacted, then the people, in order to get the registration, they used to file a memorandum and etc. Now everything has gone digital. So that practice is like more or less digitalized. You won't see the memorandums, the original form size, which used to be prevalent around 2012, 13, 14, etc. So establishment of board is the next thing. This is basically board for the benefit, like it can give recommendation to the government and what could be done for these companies. And all kinds of the members are involved in this particular exercise. So these are the things. Now, the next important definition is, or the section is, the definitions we have already covered. Chapter 4. So now what they are supposed to do and how they get the recommendation and why the changes in the IBC has been made for the benefit of these enterprises, because there is a structured mechanism by which one can claim the benefit of these provisions. And there is a recommendatory mechanism. So measures for promotion and development, the central government may, from time to time, for purpose of facilitating promotions and development and enhancing the competitiveness of these enterprises, by way of development of the skill, employment, management, entrepreneurs, providing technology, upgradation, marketing, so and so, guidelines or instruction as they deem fit. So this is the first thing. Second is the credit facilities. The policies and the practice in respect of the credit to micro, small, medium enterprises shall be progressive and such as may be specified in the guidelines instruction issued by the Reserve Bank from time to time to ensure timely and smooth flow of the credit touch, etc. So there are concessional rates. There are some benefit which has been given by the Reserve Bank of India while granting the loans. And there is a procurement preference policy. For facilitation of the promotion and development of the MSME, central government or the state government by order notify from time to time preference policies. So if you see the government department or most of the public sector undertaking, then they are required to procure certain percentage of the raw material, finished material, goods and services from the MSME. So that particular requirement finds its basis under this act. Sometimes you might come across the forms where many of the private companies, in order to avoid the liabilities under the MSME Act, take specific declaration from their vendors that they are not registered as an MSME, only then they enter into a contract. So that's the downside rate of it, but that is there. So both these practices of procurement as well as that undertaking traces their origin from this particular section. Now, liability of buyer to make payment. So this is where it is important for a resolution professional to understand these few sections. It can be used as a weapon, it can be used as a sword as well. So 15th is liability of buyer to make payment. So we have seen the definition of the buyer earlier in the definition section. Now what is the liability here? Where any supplier, the definition we have already covered, supplies any goods or renders any services to any buyer, the buyer shall make payment thereof on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before the appointed day, provided that in no case the period agreed between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance of the day of the deemed acceptance. So there is a definite timeline by which the interest will start running. Either it is by the agreement between the parties or by this date, the 45 days. So this is the timeline. If sometimes there are two practices which are prevalent, sometimes there is an interest clause built in, sometimes the entity is notified as an MSME. So the question will arise that when entity is registered as an MSME, whether the contract will prevail or this section will prevail. 1, 2, what will happen to the clauses of interest? So first we will go to the section, and after finishing the reading of the section, we will come to that precise legal issue. So from date from which, rate at which interest is payable. So this is very important. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the buyer and the supplier or in any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on that amount from the appointed day, or as the case may be, from the date immediately following the date agreed upon at 3 times of bank rate notified by the Reserve Bank of India, Reserve Bank. So why the people go to the MSME Act? For the simple reason is this particular section 16, which clarifies multiple things. First, what is the outer limit when the calculation will start running? The outer limit is given in section 15. We have already seen the 45 days. I will read again section 15 just after finishing this section. First, the outer limit has been defined. There is a purpose because of which it has been defined. Second, this particular section will prevail irrespective of the agreement between the parties. Third, the rate of interest is thrice of what has been prescribed by the Reserve Bank. So as of today's calculation, it hovers around 18 to 20%. This is the only law where even if there is nothing has been specified in the contract, the person claiming it can claim at that particular rate. So now I'm falling back on these two sections because these are the most important sections, which are frequently used in all these proceedings.
Sir, can I interrupt you here a bit?
Yes, sir. Most welcome. I'm really happy.
Sir, you're talking about the 18% rate as prescribed by RBI.
No, it's
Prevailing
roughly
rate is
calculation.
6%.
So so 6 and you multiply it by 3, last line of section 16. So it will come around 18%.
Okay. Got it, sir. Thank you. I thought it is 18%, then it goes more than 50% in that way.
So it's right. Normally it is around the FD rates available. So FD rates is now hovering around 6%, and then you multiply it by 3. If the FD rate is 7, then you go it. So the RBI rate is notified by a gazette. So you take the interest period rate of that particular period, and then you multiply by 3. So actually, when you are drafting the claim before the MSME authority, so you have to take out the rate which has been prescribed by every year or every time frame, and then you accordingly calculate. So it hovers, sometimes it's 18, 19, 20, 21. That's the range, normal range. It's not absolute, it's hovers around.
Sir, one more thing. Okay. One more question and query is in my mind. It may be that asking this prematurely, because we have long way to go. Suppose I'm an RP and registered under MSME. So like, the COC is not making the payment, which normally, I mean, in most of the cases it happens. So can I claim like, this interest portion from my COC?
First, you have to be registered like that, and then there
Yes.
is to be agreement to that effect.
Agreement.
Yes.
So
So,
agreement never takes place. So far as like, when I give the consent and when the resolution is passed, like, this kind of lines are missing in that.
that's what you have to force them to
Yeah.
agree. If you are not, so the thing is, the law is still evolving. Okay, I wanted to come to that topic at a later stage, as you have said. Rajkumarji, what happens is that first, as a professional, I don't think you can register as an MSME. One, two, even if we take the example like if the CD is MSME and it has to recover from some third person, then this act can be used. But if some MSME files a claim, I'm taking an example, MSME files a claim at the rate of 18% to the CD saying that this is the goods supplied, the value of say was 1 lakh rupees, and now I will calculate 18% monthly compounding. So monthly compounding is significantly higher. 18% monthly compounding will go a lot high. So the amount gets multiplied very fast, whether you are supposed to accept that claim. So for the time being, there is a very limited jurisprudence on this issue. There are few of the cases which has been decided. So the principle which can be deduced from those cases is like this. If there is no agreement pertaining to interest, then interest is not payable as far as IBC is concerned. So far the last position with regard to the claim is concerned in IBC in section 9 petition, they are not giving the claim of interest as per the MSME Act. And the reasoning which has been adopted by the tribunals, which is susceptible to the challenge or overturning by the higher forums, NCLAT, High Court, Supreme Court, is that what is the rate, whether which section will prevail while calculating the interest. But so far they are saying, since there is no agreement between the parties to charge the interest as an MSME Act, and therefore they are not giving. So that's the position as far the time being is concerned. But as an RP, the CD can always invoke MSME in their favor. It's a time-consuming process, but in some of the states, it's really fast. In some of the states, it's very slow. So that interest question is really tricky. So how it becomes 50%, I'll read it again. A
Just
combined
to
reading, it will really help.
okay, just to add it further, can I make the principal claim? I mean that interest portion, I being in the capacity of RP or to MSME for the interest, because there, like, there is no specific clause regarding, like, going for agreement. It is by default. Is it possible, sir?
No, I'm afraid like right now you don't have any judgment in your favor,
Okay.
to my best of knowledge. So I'm reading 15 again. That's an interesting thing because that's the timeline starts and 16 is interest rate. Those are the most critical sections in the MSME Act, where any supplier supplies any goods or renders any services to any buyer. The buyer shall make payment thereof on or before the date agreed upon between him and the supplier in writing, or where there is no agreement in this behalf before the appointed day, provided that in no case the period agreed upon between the supplier and the buyer in writing shall exceed 45 days from the day of acceptance of the day of deemed acceptance. So as soon as there is a deemed acceptance, the period commences for the payment of interest. That's the significance of the section 15. 16, again, interest rate, where any buyer fails to make payment of the amount to the supplier as required under section 15, like the deeming date, the buyer shall, notwithstanding anything contained in any agreement between buyer and the supplier, or in any law for the time being in force, be liable to pay compound interest monthly rest to the supplier on that amount from the appointed day, or as the case may be, from the date immediately following the date agreed upon, at 3 times of bank rate notified by the Reserve Bank. So the calculation is, if the Reserve Bank says that interest rate is say 5%, so you compound it to 5 multiplied by 315, and then it is a monthly compounding. So every time it gets compounded monthly. So it's a huge amount. And if you are calculating the interest rate from the yearly, then it will easily cross a significant milestone. So now you can calculate like actual percentage will be how much. So that's why the MSME provisions are invoked.
Sir,
Hopefully
this
I'm clear.
yeah. This section, sir, 16 is an overriding kind of situation.
Yes. So section 16 overrides everything, every other law, as well as the understanding between the parties.
So, like, even though, like, I don't enter into an agreement kind of thing for interest, like, this, I can I take help of this section?
Yes.
Again,
even if there is no agreement, you can take help of this section. Even if your agreement prescribes any other rate, you can take it. So I'll read it again. It's notwithstanding clause. Where any buyer fails to make payment of the amount to the supplier as required under section 15, the buyer shall, notwithstanding anything contained in any agreement between the parties, between the buyer and the supplier, or in any law for the time being in force, be liable to pay compound interest with monthly rest to the supplier on the amount from the appointed date, as the case may be, from the date immediately following the date agreed upon, at 3 times of the bank rate notified by the Reserve Bank. So it overrides law, it overrides the agreement. It's the 3 times, and it's monthly compounding, and it starts after the deemed acceptance. In any case, not later than 45 days.
sir, can I consider my COC as a buyer in the case, supply, as I am supplying services? No, na?
Professional services are not, I don't think it's covered in MSME, and it should not be covered actually. Otherwise, there will be mayhem. There will be a lot of bloodbath. So yes, so it's goods and services. If you consider yourself in because of GST services and you file it, it is yet to be tested. Like, but to my understanding, it should not be there. So recovery of the amount due. So once you have fixed the amount, the rate of interest, then what is the recovery mechanism under the MSME Act? So recovery of the amount due is for any goods supplied or services rendered by the supplier, the buyer shall be liable to pay the amount with interest thereon as provided under section 16. So I'll just pause here and I'll say, if you become a service provider, then the people can sue you for services not properly provided. That's one part of it. And secondly, the whole idea is to give benefit to those particular segments, goods and services, not to everybody else. So then, in order to enforce your right, there is a mechanism provided. So what is this? Section 18. Reference to Micro and Small Enterprises Facilitation Council. So this is a body which is being constituted, which is constituted and which is functional in almost every state. And even in one state, there are multiple branches of these facilitation councils. Just a second, sir. I'll just yes. So now what is the mechanism? The mechanism said, notwithstanding anything contained in any other law for the time being in force. So that's also a notwithstanding clause. Any party to a dispute may, with regard to any amount due under section 17, make a reference to Micro and Small Enterprises Facilitation Council. So the dispute has to go to the Facilitation Council. There is a mechanism. Sometimes in Delhi, it's completely online. In some of the states, it's completely physical. It depends upon the jurisdiction to where you can go and file it and what is the mechanism adopted there. There is a nominal amount of fee for filing, but it's a lot more beneficial than filing in the court. Because in court, if you are filing, then you are roughly supposed to pay the court fee of 1% of amount. As far as MSME is concerned, the fee is fixed. In Delhi, it's around 25,000 perhaps. In other state might be different, sometimes less, sometimes more. But it is not proportionate to the amount involved. So that saves a lot of money at the times of institution of the proceedings. Then what happens after that? On receipt of the reference under subsection 1, the council shall either itself conduct conciliation in the matter or seek assistance of any institution or center providing alternate dispute resolution service by making reference to such institution or center for conducting conciliation, and the provisions of 65 to 81 of Arbitration and Conciliation Act shall apply to such dispute as if the conciliation was initiated under Part 3 of the Act. So the first and foremost thing is the conciliation. What is the conciliation? That's the moot question here. So conciliation is a process by which two parties who are in dispute with each other sits in front of a conciliator, discuss their dispute, and can arrive at a settlement. The purpose of giving reference to section 65 to 81 of Arbitration and Conciliation Act is that once a settlement has been reached between the parties, it is binding on both the parties as if it is a decree of the court. And these can be challenged on extremely limited grounds. So if there is a settlement during the conciliation process, it is binding on the parties. So what happens in the conciliation? In conciliation, normally a conciliator, normally it is an SDM level officer who sits in these particular forums, and it decides, he hears both the parties, exchanges the proposal, and tries both the parties to come at an amicable settlement. So the conciliation, the word as such, is very close in its meaning to the mediation. However, as far as the Mediation Act is concerned, they do not use the word conciliation. And as far as the Arbitration Act is concerned, they do not use the word mediation. But both the words have similar or the same meaning, wherein both the parties who are in dispute with each other, with the help of a third party, neutral person, tries to resolve the dispute between them. In all the states, the practices are different. In UP, say for example, it's the officer who himself is conducting with a couple of more officers for each time when there is a dispute arises. In Haryana, it's 1 or 2 persons team. In Delhi, it's only a 1 person. So it depends that how this particular composition is working. But there are different versions and different practices which prevails in different facilitation councils for resolution of disputes. Another
Sir,
key...
how did you distinguish this? Sorry, till I missed that. Mediation and conciliation?
Right. So actually, there is no provision of mediation in the Arbitration Act when it was originally drafted in 1996 Act.
Okay.
The provision regarding the mediation was not there for a long period of time in any law. So last year, the government decided to have a proper law of mediation for the first time in India. So entire Mediation Act has been enacted.
Sir, you mean to say in 2023?
Yes, in 23 it was notified. It was enacted a bit
Okay.
earlier, but it was
Okay, sir.
notified a bit later. So it was notified in 23 only. 22 and or 23 Mediation Act. We can just check and let you know. But that's the thing. So, but there is a very slight difference between mediation and conciliation. In conciliation, it still functions as a bit of an adjudicatory power with the conciliator. By adjudicatory power, I mean that the conciliator can ask for the documents from the parties. Okay. In a mediation, one cannot. So the difference is only how you use it. Otherwise, the process is the same, the outcome is the same, and ultimately, both are binding on the parties. The appeal cannot be preferred anywhere. But when these act of the MSME was drafted, there was no mediation act, so they took the conciliation. As such, conciliation never became popular. That's why the government was forced to come out with a mediation act. So a part in the Arbitration Act is dedicated to the conciliation, and it is governed by those very fundamental principles. As far as mediation is concerned, there is altogether a separate act in itself, which defines the entire process, modus and outcome and everything. So there are two sets of the legislations which govern two different things. As far as MSME Council is concerned, they use the word conciliation and not mediation. The process will remain the same. The parties will appear before a presiding officer or a neutral, and this will be impartial. He cannot go into the merits of the matter. The parties rule the process. If it fails, then it fails. Parties can't be compelled to take any particular course of action. So that's the difference between the mediation and conciliation. So frankly, there is none except few minor tweaks and here and there. They are one and the same. But since there are two different acts, we have to say that they are different. Rajkumar ji, am I clear now?
Yes, very much, sir.
Okay, so thank you very much. So this is how it happens. Reference.
Sir, sir, even if, sir, suppose if I have given an option, that means like I entered into agreement where arbitration clause subsists. So can I do have like the choice of not getting or invoking the arbitration and going to this MSME Act under Section 18?
So this act is a standalone act. As we have seen, its use is notwithstanding anything contained in any law for the time being in force. So even if there is an arbitration clause between the parties, you can always go to the MSME. And it is not like Section 8. So if somebody goes to the civil court despite having an arbitration clause, then automatically Section 8 of the Arbitration Act gets triggered, and the court has no option but to refer to the parties to the arbitration. That's the fundamental principle. But this is not applicable as far as MSME concerned. So this is not the sole act. MSME Act, Consumer Protection Act, Competition Act, and all other regulatory laws, irrespective of the fact that there is an arbitration between the parties, if there is statutory remedy prescribed, then the statutory remedy can always be taken. Even in case of IBC, the same principle applies. So suppose there is a dispute between the two parties, or there is no dispute as such. The dispute is only limited to the recovery of the amounts and accounts has been settled between the parties. And there is an arbitration clause. So the question arises here is whether by having an arbitration clause, it should be invoked or it will not allow the parties to invoke the IBC. This question has arisen before the NCLT and subsequently before the NCLAT. And the clear answer which the judicial forums have given so far, as far as this proposition is concerned, is that irrespective of the fact that there is an arbitration clause and there is a default of more than 1 crore of rupees, then IBC can certainly be invoked. So that's how it works. Hopefully, Rajkumar ji, I'm clear.
Very much clear. Sorry, I was on mute.
No issues, sir. I'm really happy that somebody is at least asking questions. If sometimes the screen goes blank and it's very difficult to take these online sessions. Anyway, so now moving on to the next thing. They can also refer the matter to the institution centers. So, in Delhi, after the conciliation proceedings are complete, the matter is referred to the arbitration center in case there is no settlement during the conciliation proceedings. In Uttar Pradesh, the Facilitation Council itself has an inbuilt mechanism of arbitration within their own council. Similarly, in Haryana also, they have a bit hybrid mechanism where they do not refer these disputes to an arbitration center, but they have their own set of the panel judges who decide these disputes. So different places, different practices, but the fundamental remains the same, that post conciliation, in case there is a failure of the conciliation proceedings, the matter will be referred to an arbitrator or somebody who can adjudicate the dispute in accordance with law. So that's how it functions. In Bombay, there was a recent judgment. There was a recent judgment. Recent by here I mean around 1 year back or something, where the question arose whether the Facilitation Council is competent to conduct its own arbitration or whether it should be referred to a third party neutral. So Bombay High Court took a view that the jurisdiction of the MSME Council cannot be taken over and it cannot perform the role of the mediator as well as the adjudicator. So they recommended that all these matters should be referred to a third party arbitrator. What happens in this case in the Supreme Court is yet to be seen. But that's the first of its kind judgment in which it has been specifically provided that what will happen in case there is a dispute between the parties and it has been referred to the conciliation, then whether it will go to the institutional arbitration or not, institution or ad hoc arbitration. So the Bombay High Court favored the finding that it should go to the arbitration, which is not conducted by the Facilitation Council. Now,
Can you give us a citation of this case law, sir, if you have ready?
Sir, this is just the issue cropped up, so I remembered the case. I'll search it and give it. It's Bombay High Court. I think it is Justice Pardiwala or someone. I'll just give it. You drop me a message on my mobile number or email. I'll share with the citation with you. It is a couple of years back, and that's the citation. So what happens after this thing? So subsection 3 provides the guidelines. where the conciliation initiated under subsection 2 is not successful and stands terminated without any settlement between the parties, the council shall either itself take up the dispute for the arbitration or refer it to any institution or center providing alternative dispute resolution service for such arbitration, and provide provisions of the Arbitration and Conciliation Act shall then apply to the dispute as if the arbitration was in pursuance of the arbitration agreement referred to in sub-instance. So this is the guideline. What law will be applicable? Arbitration and conciliation law will be applicable. What will be the character of the dispute? It will become as in any normal dispute, like the what is going on the Arbitration and Conciliation Act. It is not mandatory for the parties to settle the dispute. Post failure of the settlement process, this things gets triggered. So even here there was some controversy. The controversy was what should be the process in those arbitration proceedings, whether it has to be like any normal proceedings or how it will work. So even in this case, a specific ruling has come which says that unless something grave is happening, in case when the dispute in the MSME is to be decided, the summary proceedings are to be used. So what are those summary proceedings? Summary proceeding basically means that pleadings are filed between the parties, they are exchanged, then there are few miscellaneous procedural hearings, and thereafter the matter will go to the arbitrator. Arbitrator, after completion of the pleadings, the timeline gets triggered, which as per the Arbitration Act has to be completed within a period of 1 year, and so forth. As far as MSME case is concerned, the court, the Delhi High Court in its judgment stated that like the process has to be governed by the summary process. So only documentary evidence, no oral evidence, and the entire process of the recovery has to be completed within a period of 90 days. So that's why there is a process, there is a difference. And if you are taking advice, it's advisable to familiarize yourself with all these small niceties in which what happens. So the 90 days, there is award come, you can challenge in 34, 37. That's a long story. So that's the provision, that's the act. Now the next section. Notwithstanding anything contained in any other law for the time being in force, the MSME shall have jurisdiction to act as an arbitrator conciliator under this section in the dispute between the supplier located within its jurisdiction and the buyer located anywhere in India. This is very important. Why? Because it provides that where the jurisdiction lies. So like in the case of the IBC, the jurisdiction in the case of the MSME goes to the place where the entity is registered. So I'll read that section again, and it will make the things very crystal clear. So it says, notwithstanding anything contained in any other law for the time being in force, the Micro and the Small Enterprises Facilitation Council or the Center providing alternative dispute resolution services shall have jurisdiction to act as an arbitrator and conciliator under this section in a dispute between the parties located within its territorial jurisdiction, located within its jurisdiction, and a buyer located anywhere in Australia. So, if the person who wants to initiate the recovery is based in Chandigarh, he can file the cases against all the parties located across India. So that's the rule of jurisdiction. It makes the task very difficult on the part of the person who has not paid. But it really becomes easier due to caseload. The mechanism is not fully effective in some of the states. But in most of the places, it's highly effective and highly result oriented. So I think I have almost completed 1 hour. If you people wish, we can take a break of 10-15 minutes. You can grab coffee, tea, everything, and we can reassemble in 10-15 minutes. Is that okay?
Yes, sir.
Yes, yes.
Thank you. We'll rejoin in just 15 minutes, 3:15. So welcome back. I hope all of you had your coffee, tea, everything. Can you hear me? Hello.
Yes, sir.
Yes, sir. Yes, sir.
Yes, sir.
Thank you. So we were on remedies, which remedies are available to the people and how those can be invoked. So we have seen that the MSME Council can be invoked irrespective of whether there is an agreement between the parties or not. The cost implication is also clear. It is significantly lesser than the civil suit. Sometimes you do not even need lawyers in the MSME Council to appear. The parties can go there, can themselves negotiate. Another thing is regarding, there is a question, there is a thing like deemed acceptance. So the recovery start only when there is a deemed acceptance. But if there is a dispute regarding the quality and etc. like in IBC, there is no evidence as such which takes before the council. It might be decided in the arbitration, but arbitration is binding. The process of arbitration would be summary, because Delhi High Court has come out with a judgment in which it says that these arbitrations have to be decided in a summary fashion and to be completed within a period of 90 days after the completion of the pleadings and etc. So as such, the time limit within which an award to be given is very fast. This is the only mechanism in which, at least theoretically, the RP can recover some amount from the customers if he really wants to invoke. If the COC gives him the permission to initiate those proceedings and those proceedings fructify. But merely by sending the proceedings to the MSME Council, there might be some settlement. It is one of the least explored territory so far as the IBC and the recovery of the dues by the CD is concerned. But as an RP, you must keep that in mind. If the notice is given, the fear of 3 times of the interest rate prescribed with monthly compounding is huge, and many party may come to the settlements.
Sir, but there is an obstacle here because the IBC is a time-bound process.
Right,
And
sir?
do you think that COC normally gives that kind of permission to initiate action?
Whether they give or not, the RP has to perform its duties as per the IBC, which is maximization. When the recoveries are due, the RP can very well initiate the conciliation proceedings. And this is the only process where the result can come in such a short period of time. Otherwise, it can't. Like,
No, there is no other. IBC cannot, pass such a kind of in such matters like any judgment or not. And one more thing, sir, you mean to say that if I have a multiple place of business, so I can take the advantage of my filing, MSME application from all this jurisdiction.
yes. So if suppose you have supplied the goods as a CD across India, you can file all those proceedings within the jurisdiction where the CD is located. So the cost implication is less. The time period theoretically and sometimes in the practical also, it's significantly less than the court and any other thing. And the result can be achieved, or in fact, a viable threat can be given to the people who are not paying to the CD. So all these advantages are available in this act, and no other act gives those advantages. And even after assuming that there is an award in your favor, the conciliation fails, the matter goes to the arbitration, and the award is in your favor, that award can be transferred during the liquidation process as not readily realizable assets, and it will fetch much more value than a mere dispute or a chance of recovery. So overall value which a resolution professional can derive by using this act is significant. Many of the
Sir, I have a practical situation here.
right,
Suppose I have some NRRA assets with me.
Hmm.
So, like, normally COC, I mean, especially the financial creditors, they do not take up because they don't have that kind of mechanism of recovery.
Right, sir.
So, so can this NRA be invoked at MSME court?
NRRA, sir, comes during the liquidation process.
Yes, it is under the CD is under liquidation.
CD is under liquidation. So I'm yet to see when the proceedings can be initiated by the CD as such. But if there are already proceedings and you have an award in your favor, then you can transfer that award as an asset which can be sold and purchased. But
No, sir, I have issued expression of interest for that.
I'll tell you what the difficulty is. Say, suppose you are a liquidator of that particular company. The CD is in the liquidation process. You already have your time frame. So chances of getting that thing get completed within that period is bit minuscule. It's not that bright. But if
So this was my question, like, I put like, the other time, like, because the IBC is a time bound process, and like, the COC doesn't want to put good money in, like, recovery of bad money.
Right. So if the proceedings are initiated at very threshold, then chances are that there might be some recovery. So
I can withdraw the application once filed during the CRP when my stage of liquidation comes up.
Why do you wish to withdraw? There is no implication as such.
Because see, in that case, like, I'll go for NRRA rather than like, waiting for MSME court to give just order. Then I have to go for I mean, what you call action to be like, for execution of that order.
See, if you already get an order, you can transfer that decree because it will become a decree of the court. If you don't get an order, then the person who is buying the NRRA will decide whether he wants to go to the civil court or etc. Because he cannot invoke this act.
That means he can continue that MSME, like, I have to, I mean, get them implemented by way of an RRA.
Let me be clear. If the proceedings have reached to an end when award is given, which is as good as the decree of the court, you can transfer it. So execution can be done by any executing court. That can be transferred as an NRRA. But assuming that by the time you are supposed to transfer the NRRA, the proceedings in the MSME council has not been fructified. Okay. Then you anyway have to sell the NRRA as it is. The other party can't jump into the shoes of the MSME because the law prohibits. If you recollect, we have dealt with the section that actionable claim can't be sold in MSME. Money
Okay,
and
this is the transfer of like claim. Yes, sir. Very right.
Thank you. So now you got the clarity, na sir?
Yes.
Thank you. So the next question is application for setting aside a decree, award, or order. So why this?
Sorry.
No problem, sir. So why this is the why? What is the cost of fighting a litigation against MSME? So in order to ensure that the people should not frustrate the claims of the MSME by simply filing the appeals, there is a very high threshold which has been prescribed under the next section. What it says, I'll read it. No application for setting aside any degree, award, or order made either by the council itself or by any institution or center providing alternate dispute resolution services to which a reference is made by the council shall be entertained by any court unless the appellant, not being the supplier, has deposited with it how much? 75% of the amount in terms of the decree, award, as the case may be. The other order in the manner directed by such court. So, if a person other than the supplier choose to challenge the award, which is either given by the council or ADR center or arbitration to which it is referred, then to challenge it, 75% of the amount has to be deposited. So the cost is really high. Unless the case is very meritorious, the law wants to deter the false appeal in the MSME Act. So, in order to fructify the right of the appeal to challenge the award that any claim is not made out, 70%, 75% has to go upfront. Till that amount is paid, the appeal is stillborn. It can't be considered by the appellate courts. That means it automatically fails. So the financial cost of challenging the award in the MSME is very high. So is the interest act. So if you see the combined effect of these sections, one, it overrides law, it overrides agreement. The payment period commences from the date of deemed acceptance, and thereafter interest rate becomes payable. That interest rate is specified thrice of the amount prescribed by the RBI, and that too have been compounded monthly, where the amounts get doubles in like less than very soon, in few years, not even 5 years. Then if you want to challenge that award, then you have to deposit the 75% of the entire amount. So it not only covers the original claim plus interest. So you have to deposit that much just to challenge it. So the cost of fighting against the MSME is huge if the law is followed in the letter and the spirit. Then, or other manner directed by the such courts, provided that, next proviso of the section 19, provided that pending disposal of the application to set aside the decree, award, or order, the court shall order that such percentage of the amount deposited shall be paid to the supplier as it considers reasonable under the circumstances of the case, subject to such conditions as it deems necessary to impose. So even that amount during the pendency can be released to the supplier. There is another facet of the section. So what happens, what kind of conditions which can be imposed by the courts? The court normally asks for bank guarantee. If you give the bank guarantee, they direct the release of the amount. So in case there is an adverse judgment against the supplier, the money could be recouped easily. And in the meantime, the supplier can take benefit of the money. That's one portion of it. This condition is not applicable to the supplier. So in case the award is against the supplier and they want to challenge it, no amount to be paid. There is no cost attached to the appeal. So they can simply challenge it. So this entire legislation is hugely beneficial to the MSME sector. And since in the last budget, the threshold of being an MSME has been increased significantly, 250 crores something. So almost all of the CDs except very large enterprises will fall within these definitions. And therefore, as an RP who is custodian, and it is his duty to maximize the asset, must be well versed with the provisions of this act. So he can fend off false claims as well as can realize the claims of the CD if it is an MSME in the lawful manner and can maximize the assets. So then the other sections will follow. Establishment of the facilitation council, composition of the facilitation council. So there is nothing specific relating to the claims, etc. Like these are important, but you can read whenever you have the time. Now, the another most important section is just a second. Most important section 23, few more important. Interest not to be allowed as deduction from the income. So most of the RPs are well versed with the finance and the taxation laws. So whenever an amount is paid, it is treated as an expenses under the Income Tax Act. But this is not allowed as far as the MSME is concerned. So what the section says, it will make more sense after I read it. Notwithstanding anything contained in the Income Tax Act 1961, the amount of interest payable or paid by any buyer under or in accordance with the provisions of this act shall not, for the purpose of computation of income under the income, be allowed as deduction. So there is multiple front war in the favor of the MSME. One, you have to pay the interest which is thrice of the rate prescribed monthly compounding, and this entire amount cannot be used as a deduction. That will be treated as an income on which he has to pay 30% interest. Applicable rate. So huge disadvantage to the people who deliberately not paying the money due and payable to the MSME. This is very important and relevant. Now, the next section, 24, overriding effect. The provisions of section 15 to 23. So if you recollect, we have started with section 15, the important provision. Liability of the buyers to make payment. And we just finished section 23, which says that Income Tax Act, this will not be a deduction. So from this section to this section, it says the provisions of section 15 to 23 shall have the effect, notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So that's a huge benefit for the
Manisha, suppose I have contested, I have gone in appeal and deposited 75% of the cost. Okay, suppose that like, the outcome takes say around, say more than an year or 2 years like that. So can I take this exemption for the time being so far as making the payment of interest on behalf of the person who is making this 75%? Will they get the benefit of a moratorium or exclusion?
See, moratorium will be applicable if you are the buyer. So I'll reframe the thing. There are two kinds. One, the CD is trying to recover the money from the others. Okay. Then the CD will definitely get the benefit of the amount which is due and payable. The buyer is on the other side, to whom the CD has supplied the goods. If the buyer has gone into appeal, then he is supposed to pay 75% then and there. In that 75%, suppose the interest component is, say, out of 100 rupees, the interest component is 60 rupees. Then that 60 rupees will not be allowed in the income tax as a deduction. It will be taxed as an income of the assessee. Okay. In that particular case, there is nothing which the moratorium affects. Let's take the other way around. If the Buyer is the MSME. Somebody else wants to recover from the MSME, and this MSME has gone into the insolvency. Moratorium gets triggered. In moratorium, everything comes to a standstill. Even the claim, the interest cannot be claimed because IBC does not recognize the interest payable unless there is an agreement between the parties. So there is nothing which can happen against the CD and no adverse consequences follows as far as the CD is concerned if it has gone into the moratorium. Now that question of the realization of the income. If it is a previous year in which he has to pay or he has paid, then automatically in assessment that will be realized as income. But once the CD has gone into the insolvency, then it's not an income as such. There will automatically be stayed. Hope I'm clear now.
Yes, just to add it further, suppose I am the contestant, I have gone into appeal. I'm not talking about IBC. I'm talking purely about MSME. So suppose I am required to pay to my supplier, which I couldn't. So they have initiated MSME. Now the thing is that I have there is an order. I want to contest the order. I have deposited 75% of that, whatever it is, with the court. Now the thing is that suppose this matter goes on suppose let's say around 2 years. So do I need to pay the interest of all these 2 years till that the final verdict comes?
No, that's
Or
what
can I take exemption?
I'm trying to say. Once this IBC has triggered, Section 14 has come.
Sir, I'm not talking about IBC. IBC pure is a plain vanilla MSME application.
Okay. Then yes, if there is no IBC, you have to pay the interest when the matter is pending. That's called pendent light interest. So let me rephrase your question if I have understood it correctly. You mean to say that there is a buyer who has not paid, he has challenged the award which is being awarded by the MSME Council after depositing 75%. So whether he is supposed to pay the interest, that's what your query is. So
Yes.
it has two answers. One, the amount which has deposited before the court, automatically it goes into the fixed deposit and interest is being paid. Okay, so that's as good as if you have complied with the award. Okay, for the remaining amount, the court can direct you to pay, or if you if you don't pay, then the interest continues over that amount.
No, suppose the time taken by the court is 2 years. Suppose
Even
I have made the payment. Yeah, in that case, suppose I made the payment in 2024 and I've challenged the award. Now the matter it decided in say around 2024. So for these 2 years, I am required to pay interest also, or it will be automatically suspended.
Unless there is a stay of the award, the interest will continue to occur.
Okay. Okay.
The
That was my
75% gives you the right only to go into the appeal. It does not mean the stay of the award as such. You still have to make an application for stay. If the stay is not granted, then obviously the interest will continue.
clear, sir.
Please. So now we have seen the deduction from the income. So there has to be corresponding section of the amount. That's why in between, section 22 will become important. What is section 22? Where any buyer is required to get his annual account audited under any law for the time being in force, such buyer shall furnish the following additional information in his annual statement of accounts, namely what? The principal amount and the interest due thereon, to be shown separately, remaining unpaid to any supplier as at the end of each accounting year. That's a separate entry. The amount of interest paid by the buyer in item of the section 16, along with the amount payable to the supplier beyond the appointed date during such accounting year. The amount of interest due and payable for the period of the delay in making the payment. but without adding the interest specified. So all these entries, which has been prescribed in 22, has to be so that's the MSM used by the insolvency professionals as an IP for contravention. So the penalty is minuscule, 10,000, 5,000, 10,000 to 1,000, etc. Nothing significant. Further, section 28 is important. No court inferior to the metropolitan or magistrate of the court shall try any offense punishable into this act. And that's it. That's the entire act. So now we just completed this MSME Act, and I'd like to ask guidance if anyone has any questions so far, any doubts. I assume that you people are reserved your question till the end. Yes.
Sir,
But
as per the IBC this MSME provisions, one has to be get themselves registered, then only the benefit arises.
right. Yes, registration is mandatory. Without registration, no benefit. So there are a couple of Supreme Court cases which has happened. First, there was a position in the Delhi High Court which says that a person once registered can claim the benefit of the MSME Act even regarding the contract which were entered prior to the registration.
Come
Then,
again, sir, not clear. Even I can invoke even like, I'm not registered and I've registered post happening of activity or default.
yes, so there was a judgment of Delhi High Court which provided that MSME is a beneficial legislation. So even if you registered, say, in 2010, and the agreement with your supplier was entered into in 2007, you can still claim the benefit of the MSME Act. But recently,
It is prior to your happening of
yes. So recently there were two Supreme Court judgments. One was the Shilpi Industries, in which in two successive judgments of the Supreme Court, it has been stated that the benefit can be claimed only post-registration. So prior to the registration, it is not applicable. Post-registration benefit can only be claimed MSME. So that's the position as of now. If the judicial position may change, may not change, very difficult to predict. But as of today, one can claim benefit of the MSME Act only after the date when he registered. The rationale given by the Supreme Court for this thing was that how a person will know that he can be saddled with the liability which is so huge in terms of the interest, and therefore unknowingly a person can't be punished, and therefore only after the registration this liability may fall upon the buyer. So that's the position. There are still some conflicting judgments in the High Court, but Supreme Court more or less clear on this aspect. As far as
Sir,
the
is there any additional duty cast on the supplier to intimate them, as you rightly said that okay, vendor code is not getting created unless until you are registered MSME.
right now there is no such requirement. I haven't come across any. So the
But it
only
is just a matter of practice that okay, it is to be intimated that okay, I am a registered supplier is the registered MSME.
actually some of the companies who want to avoid making payment to the MSME first take a declaration from all the vendors that they are not MSME. If they are MSME, they don't even award the contract.
Very peculiar situation.
So you may like if you deal with lot of clients like this nature, so even as a professional, suppose if you are serving some large enterprises, so every year they take a declaration that you are not MSME, otherwise they will not hire you. So that's the practice, but as such, there is no positive duty casted upon the enterprises to the uh, intimate the buyer that you are an MSME.
The buyer can take the plea that they were not aware of that this company is MSME.
No, they can't.
And
They can't. So here we close the so far the topic of the main MSME Act is concerned. Now we take the second limb of the entire second limb of the entire thing, which is the IBC. So in IBC, the MSME was basically came by virtue in 2018. So section 240A was introduced, and because of which the entire dynamics has changed of who can file the resolution plan. So first we will trace this development backwards. First we will read section 240A, what it does. So what it does is, it in simplistic term we can say that it allows the management, ex-management of the MSME to give a resolution plan. How? So I'll read the section and then I'll give my thoughts on it. Notwithstanding anything to the contrary contained in this code, the provisions of clause C and H of section 29A shall not apply to the resolution applicant in respect of the corporate insolvency resolution process or pre-pocket insolvency resolution process or of any micro, small and medium enterprises. We all know, dealing with the IBC, the 29A is a disqualification. So original thought process was that the shareholders and the promoters are responsible for the company's affairs, and since the company is going into the insolvencies, they are the person responsible for it. They might have indulged in certain activity which is not ethical, not moral, or somehow they are not capable or wise enough to handle the company. Therefore, shifting of the management from shareholders in control to the creditors in control. And by way of resolution plan, such shareholders or the ex-management should not be allowed to regain the control of the company. And for that very purpose, 29A was introduced. So first and foremost, the IBC has evolved at many times. One of the fundamental concept of the IBC was transfer of controls from the shareholder to the creditors. When this transfer has happened, the government very soon realized that there was no impediment on the people who are the shareholders of the company to give the resolution plans. So they are washing their companies, making it clean and regaining the control of it. In order to avoid that thing, they enacted 29A. The 29A provided various stringent parameters. If you fall in any of these parameters, then you are not allowed to come and float a resolution plan for the company. Now, the next challenge emerged for the government is that many of these companies which were going under the insolvency, there are no takers for this company apart from the ex-management. Many of these companies were very small. It was because there are so many in numbers that taking them into the insolvency was distorting the market. Therefore, the government was forced to come out with an amendment to the IBC in which an exception was created to another exception. So first exception was 29A, saying that the ex-promoters can't come in. And the second exception of that exception is the promoters can come in if they are MSME was created. But the language of 240A, subclause 1, is very categorical and clear. There are only two provisos which are not applicable in the 29A. One is clause C, another is clause H. We will go to those clauses after finishing this entire section. So subject to subsection 1, I'm reading clause 2 of 240A. Subject to subsection 1, the central government may, in public interest by notification, direct that any of the provision of this code shall not apply to micro, small, medium enterprises, apply to with such modifications as specified in the notification. So these are the two things. No other notification has come so far. The benefit is limited in 29A and reverse insolvency. We will cover both those topics. I'll try to finish both those topics within the time period. A draft of every such notification, both House of the Parliament, etc., the rest of the sections is not that relevant. Last explanation of this section is relevant explanation. For the purpose of this section, micro, small, and medium enterprises means any class or classes of enterprises classified as such under subsection 1 of section 7 of micro, small, medium enterprises development. So the distinction between micro, small, and medium is irrelevant for the purpose of the IBC. As long as the company is registered under the MSME, it can take the benefit of the IBC. What is required is Udyam registration. It's very easy and fast forward to come.
Sir, even if I'm into a trading
The
business.
limits are. So what type of the businesses are covered? That is to be seen by virtue of section 7. Even the trading business can be, like if you see now the categories, they are very exhaustive. There are except few things, everything under the sun is covered in those categories. It's how you frame your application. If you try to go to the Udyam registration, you will see that they are very exhaustive. There are several of them. Now, coming back to section 29A. So I'll just see that I'll just again, only two clauses are relevant. Clause C and clause A. We'll read first those two clauses of 29A. So let's come to 29A. So 29A it's a very lengthy section as such. And this is here. So 29A, persons not eligible to be resolution applicant. A person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert with such person, A, is undischarged insolvent. So if somebody is an undischarged insolvent, even if it is MSME, that section will not save. B, is a willful defaulter in accordance with the guidelines of the RBI. So if somebody is a willful defaulter, he will not be saved. even if it is an MSME. What will be saved is C. At the time of submission of the resolution plan has an account or an account of a corporate debtor under the management or control of such person or of whom such person is a promoter, classified as a non-performing asset in accordance with the guidelines of the Reserve Bank of India issued under the Banking Regulation Act 1949 or the guidelines of the financial sector regulator issued under any other law for time being in force, and at least a period of 1 year has elapsed from the date of such classification till the date of the commencement of the corporate insolvency resolution process of the corporate debtor, provided that the person shall be eligible to submit the resolution plan if such person makes the payment of all the overdue amounts with interest thereon and charges in relating to the non-performing assets accounts before the submission of the resolution. So if the person is a promoter, his account has become NPE, 1 year has elapsed, he has been disqualified from the giving the resolution plan. But if such company is an MSME, they can still give the plan irrespective of this particular section. So that's the first part of it. There are several provisos which are important here. Provided further that nothing in this clause shall apply to the resolution applicant where such applicant is a financial entity. So if somebody has fully paid the amount, this section even otherwise does not apply. This is not applicable to the NBFC and banking company. Explanation 1. Related party. For the purpose of this provision, the expression related party shall not include a financial entity regulated by the financial sector regulator if such financial creditor or the corporate debtor and its related party, the corporate debtor, solely on account of conversion or substitution of debt into the equity shares instrument converted next. So if somebody has taken the shares in order for the satisfaction of the debt, it will not be covered. For the purpose of this clause, where the resolution applicant has an account or an account of a corporate debtor under the management or control of whom such person is a promoter classified as a non-permanent, such account was acquired pursuant to a prior resolution plan approved under this code, then the provisions of this clause shall not apply. So these are the contingencies in which it is not applicable. 1, if the account has been acquired, we are going backwards. If the account has been acquired in an insolvency process. 2, if it is a related party and a financial regulator and the financial sector entity who has acquired the shares, still it is not applicable. If somebody has paid, still not applicable. But when it is applicable and it's a related party and it is an MSME, then also it is not applicable. So this is section C. Now, D. He has been convicted of any offences punishable with imprisonment for 2 years or more under any act. Then he is not eligible. MSME will not save it for 7 years and more. Then
Sir, suppose that resolution plan has been submitted by 4 persons. So out of them, one has been convicted and falls in these 2 clauses. That resolution plan is still be valid for rest of the 3 persons who have not been convicted.
So it can't be segregated unless there is a provision in the resolution plan. So the disqualification applies on the resolution applicant, not on the plan. 1. 2, I haven't seen such a case law where a disqualified person is acting in concert with the qualified person is giving the plan. But this question is very pertinent. What happens if a related party of the promoter is giving the plan? Because by virtue of the fact that this is an MSME, so there is an NCLT judgment which says that it can be done. So only to that limited extent, but that is only for the purpose of the MSME. As far as all other disqualifications are concerned, they are absolute. So if any of them is disqualified, then entire plan goes. Then there are two more things which we should be covering. The one another question which arises, which is in the first line. I think the answer of your question lies in the first line. So what it says, a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly in concert with such person. Which means a person has been convicted, cannot give a plan in collaboration with another person who is not convicted.
Yes.
Am I clear, sir?
Yes, very much.
Thank you, sir. Then there is another question which comes where there was several changes in the position, is if you read the first line of subclause C, it says at the time of submission of the resolution plan has an account. So the disqualification in this particular section has a specific date. This date is when the resolution plan is submitted. So there were cases when the corporate debtor was not a MSME. It got, because they were not even eligible at that point of time. Then COVID came, thresholds were increased, and post increase of that threshold, automatically the person became eligible, and thereafter the registration was obtained under the MSME. So the question arose whether such person can give the resolution plan. NCLT, particularly NCLT in Delhi, took a view that such persons are disqualified because they are trying to circumvent the law. And since the company was not registered as an MSME at the time when the company was admitted to the CIRP process, therefore they are not entitled to give the plan. The matter reached in a different context before the Supreme Court. One of the resolution professional allowed such MSME to give the plan. Somebody filed a complaint against him in the IBBI. That matter was challenged in the High Court, and then ultimately it went to the Supreme Court. The question before the Supreme Court, whether the IRP has committed any illegality in allowing the promoter to give the resolution plan, the Supreme Court says no. The IRP has not committed any illegality. Section 29A is very specific. In fact, in some of the sections, the word used is at the time of the submission of the resolution plan. So the critical date of application of Section 29A is date of the submission of the resolution plan and not the date of admission of the CIRP. So if the company got registered as an MSME because of the prior application pending before the MSME, or because increase in the limit, or because virtue of the resolution of the COCN or the actions of the RP, it got registered subsequently. Since this is a beneficial legislation, they can very well take the benefit of Section 240A read with 29A and give the resolution plan. So that was the moot questions which was answered affirmatively by the Supreme Court. So this is, we have covered C, F, C, we have covered D as well. Disqualified as a director, E. Security exchange media SEBI disqualified is F. G is if there are any avoidable transactions. So G says that has been a promoter in the management and control of the corporate debtor in which the preferential transaction, undervalued transaction, extortionate credit transaction taken place in respect of which an order has been made by the adjudicating authority. And the next important section is H. But I think the second part of G is still relevant, provided that this clause shall not apply to any preferential transaction. That the resolution H is important. Has executed a guarantee in favor of the creditor in respect of the corporate debtor against which an application for insolvency is made by such creditor has been admitted under this code. So the guarantors also this clause will not apply. And therefore, in 29A, a person can take benefit of the 29A as an MSME only if he is covered in clause C and clause H, otherwise not. And the simple reason for clause C and H is that in any case, these proceedings are going to get triggered if the company is admitted in insolvency. If you really want to give the benefit of to the MSME, then you cannot have a law in which they cannot take the benefit of 29A. So the limited benefit has been given. So hopefully I'm clear till now. Anybody has a question? I assume that everybody has understood everything. I'll request if somebody can switch on the camera. I think there is none of the participants have switched on the camera so far. So I'm not sure that anybody is attending it or not. Thank you. Thank you very much. It helps a lot to see the faces. So far, I assume that I'm clear. If any of you have any questions, sir? Sir, you are not audible. Could you be more louder? So I lost somewhere. I could not hear. There was some question, but I could not hear. So I'll jump on the next and the last portion. The IBC given. This is on prepackaged insolvency. It was not hugely successful, but still it is in the books. The relevant sections is very well explained in one of the diagram which has been given by the IBBI. Could you see the diagram?
Yes.
Thank you. So this is the classical diagram, which is prepackaged insolvency. So as far as the prepackaged insolvency is concerned, specifically MSME has been mentioned. So this entire prepackaged insolvency was originally brought in to give benefit to MSME only. So I'll just go to the section and show you the part which deals with it, which says that it's for the benefit of the MSME. So we'll go to section 54A. Hmm. 54A. So it's chapter 3, it's one section, it covers everything. So 54 says that an application for initiation of prepackaged insolvency resolution process may be made in respect of the corporate debtor is classified as micro, small, medium enterprises under subsection 1 of section 7 of the so-and-so Act. So this entire thing has been designed for the MSME. Not very popular, but it's available on in the book. This can be used as a strategy in your advice. If you want to take a company in the insolvency, so right now the threshold has gone to 1 crore rupees default. If the default is not 1 crore, you can't take a company in the insolvency. But under 54A, you can still take the benefit of the IBC and insolvency if it is registered as an MSME. So a creditor, be it operational or financial, cannot initiate the insolvency, move an application under 54A, it can take advantage of it. That is one of the structuring which can be advised by the resolution professionals. And in this entire process, the involvement of the resolution professionals starts even before the process starts. So what is a pre-packaged insolvency? As the name suggests, everything is pre-packaged. In a normal insolvency process, what happens is there is a default. The matter goes to the NCLT. NCLT says that there is a debt, there is a default, moratorium applies. RP comes in. The first thing he is supposed to do is then post an advertisement, say, invite claims. Claims are collated. COC is constituted. The affairs of the memorandum. Form G is invited. Resolution plans are invited. Prospective bidders are identified, highest bidder. Matter is put before the COC. COC decide which proposal is the best. And after approval of the COC, it goes before the NCLT. This is the entire process in summary. This entire process is pre-packaged in the pre-packaged insolvency 54A. That's why the name is pre-packaged insolvency. So what are the things that has to be completed even before the pre-admission stage is given on the left side of this chart. So there has to be mutual understanding. The list of creditors has to be prepared. Identification of IP to act as an RP has to be identified even before the admission. Declaration by the majority of the directors and the parents that it will be able to satisfy and whatever it is. Shareholders' resolution has to be there. Consent of the majority of unrelated FCs to the proposed resolution plan should be there. There has to be report of the RP. Then application to adjudicating authority for admission has to be made. Then there has to be updation of the claim and preliminary information memorandum and base resolution plan. All these things has to be there at the pre-admission stage. Once entire background is ready, then the application is moved to the adjudicating authority. So adjudicating authority can admit or reject the application. If the adjudicating authority admits the application, then the resolution professional constitutes a COC. Creditors are already known. So easy to constitute. Within 7 days, it has to be constituted. Then the CD submits the base resolution plan, which was prepared before the process and where the majority of the financial creditor have given their consents. So the base resolution plan is submitted. The base resolution plan can be of two types. One, there is a zero haircut to the operational creditor, or there is a haircut to the operational creditor. If there is no haircut, then automatically it goes for the approval of the base resolution plan in the COC. In case there is a haircut to the operational creditor, then alternative plans are invited. So base resolution plan, alternative plans are invited. Then, and alternative plans are invited on a significant improvement. So the first thing is BEP is base alternative plan is not significantly better, then it again goes to the COC. If it is significantly better, then the COC can approve the another plan which is not submitted by the promoter. And if no plan is received, then again the base resolution plan can be approved. So the condition is, the first is, if there is no haircut, the base resolution plan submitted by the promoter can be approved as such. If there is a haircut, still it can be approved if no alternative plan is received or the alternative plan is not significantly better. So once it is approved by the COC, then it goes for the approval of the adjudicating authority. And once the adjudicating authority approves, it becomes a resolution plan. The entire thing has to be completed within 90 days. So that's what prepackaged insolvency is all about. It's fast, it's simple, but major challenge is the people are not able to convince the stakeholders that there could be a plan even at the stage prior to the commitment and everything. If there is a plan, why don't they go into one-time settlement? But be that as it may, this is the entire concept of the prepackaged insolvency in a very simplistic terms.
Sir, what should we do as a fraternity to, strengthen this piece of legislation to see success at?
Perhaps you have to identify the companies which can take the benefit of this thing and convince them that this is a viable proposition. Applies the maximum and they don't want to give any haircut. So they don't want to take the blame. So there are very few of them, but it's still happening. So that's the second advantage. I don't have the complete answer to your question, but I'll think that if I have anything, then I'll let you know what we can do to strengthen this thing. But so far it is there. So this is the prepackaged insolvency, which is more or less applicable to the MSME and made for the specific benefits of the MSME only. So then I wish to show few judgments which are related to this topic, might be helpful. One is this. Yes,
you're
sir.
talking about PPRP or you're talking about IBC? The case.
Now I'm talking about IBC. PPRP, I think I have finished. There is
okay.
If you have any question, you can ask. There is one thing which I could not cover, that during the PPIRP, if the creditors feel that the shareholders are trying to siphon off the funds, taking benefit of the moratorium which they got in the PPIRP, then they can approach the adjudicating authority and convert the PPIRP to the CIRP. So that's one of the features of the PPIRP. So there should not be any abuse of it. So there is an inbuilt risk even after the settlement to the promoter. So there could be an allegation, and once there is an allegation that PPIRP converted into the CIRP, so they might not want to take that risk.
But sir,
Secondly,
the chance of allegation gets minimized once, it is approved by NCLT. Honorable AA.
Yes. Yes, but once it is converted into the CIRP, then it's very challenging task for the promoters to regain the control. The whole idea is that they regain the full control, still keeping the company as a going concern and everything. So that benefit goes away. So that's one of the reasons they might not want to take the risk of getting into the PPIRP. So after we have finished this thing, I'll go through few of the judgments. So far, if any of you have any questions, you are most welcome to ask. I assume that there are no questions because I can't see anything in the chat box and there is nothing otherwise as well. So coming back to the judgments. So one of the judgments, this is NCLT Chennai. And in this case, the issue was very simple. A promoter regained the control of the company, taking advantage of 29A, and thereafter he made default in the resolution plan. So he could not comply the terms. Before the court was whether because of the MSME any leniency can be given to the promoters of the MSME despite being default. The NCLT held that there is no additional advantage which has been given to the MSME units. So the relevant paragraph, I'll read this relevant paragraph is paragraph 20. A comprehensive study of the IBC and other recovery laws would, just a second, will posit the fact that once an OTS is violated, the bankers get entitled to claim the entire outstanding dues. In the present case, in order to revive the company, various reliefs and concessions were granted in the commercial wisdom of the COC. Furthermore, MSME being the backbone of the economy, Section 240A of the IBC was introduced to support the MSME units. However, that cannot be extended to the ridiculous extent of defeating the very purpose of the IBC 2016 and allowed to defeat the creditors at large. This case is a clear misuse of the provisions of 240A of IBC, and in spite of sufficient opportunity being granted, more than 2.5 years have lapsed, and the resolution applicant till date is unable to implement the approved resolution plan. Hence, the adjudicating authority is left with no other option than to order the liquidation of the corporate debtor. So apart from 240A, nothing. If there is a breach of the plan, the same consequences will follow. The company will go into the liquidation. Then there are few more notifications. What will happen if the limits will change upwards? So there is a notification of the government. The relevant portion is 5. In case an upward changes in terms of the investment in the plant and machinery of equipment or turnover both, the consequent reclassification and enterprise shall continue to avail all non-tax benefits of the category it was in before the reclassification for a period of 3 years from the date of such upward change. This is a still moot question once it left, whether the IBC will be applicable or not. It is yet to be decided in any case law, but there is something which even if the size grows bigger, as per notification, the benefits can be availed at least for next 3 years. Then another judgment. So this is particular to the interest rate. So there was a question posed earlier that what happens to the interest rate and etc. So I'll read the relevant portion of the judgment. As regards the claim of interest made by the operational creditor, it is noticed from the record that neither the purchase order nor the several invoices contained any interest liability for the delayed payment. The claim of interest so made rests primarily on the status of the operational creditor as MSME enterprises. It is true that MSMED Act specifically states that the interest shall be paid on the delayed payments, irrespective of whether there is an express agreement or not to that effect. However, it is now settled in the context of the code, IBC, that if interest is not agreed upon between the parties, it cannot form part of the operational debt within the meaning of 521 of the code, and that no such interest can be claimed in application under section 9 of the code. The correct forum for such claims is MSEFC, Facilitation Council. It is settled that NCLT is not a forum to resolve the disputes pertaining to interest claim of a MSME entity. As stated above, the operational creditor has already made an application before so-and-so in this behalf. For the purpose of this application, the claim of operational creditor for forfeiting the interest as part of the operation is found to be legally untenable and accordingly rejected. So there is already a judgment to this effect.
Sir,
However, this is coming from
in the matter of
Yes,
Siddharth
sir.
Enterprise, it is a UP,
Yes.
UP citation, UP NCLT.
No, sir, it's Mumbai bench. Mumbai bench number
Okay,
6.
it's a Mumbai bench.
Yes.
Siddharth. Okay, sir.
I'm yet to see any judgment on this particular aspect from the NCLAT, but this pretty much covers the field so far. Then there is another judgment. So this is the judgment where this is coming from Calcutta, 2022, Srinath Finvest. In this case, the question was whether if a promoter has given a plan for revival of the company taking benefit of section 240A, whether the COC is supposed to give any detailed reason for rejection of such plan. So it was held that COC can decide whatever, and it's the commercial required to give reason for rejection of the plan. So I'll come to the relevant portion of the judgment. So the allegation was the applicant, this was the allegation by the promoters who were in the management. The allegations was that the applicant had not been provided with a level playing field, although an MSME promoters keeping in view the legislative intent to encourage the promoters of MSME to pay back the amount in default, regain the control of the corporate debtor, thereby promote the entrepreneurship by allowing filing of the resolution plan by MSME promoters of applicant plan ought to have been approved by all the members. So this was the contention. The chain of events has been given. So in C, the applicant as an MSME promoter submitted its plan as he felt that he was entitled for exemption. He had not put up the same with the plan as the promoter was rejected. Later on, the tribunal directed to revert back the resolution plan submitted by the promoter for the consideration FS subject to the deposition of the EMD of 1 crore within 2 days from the date of the orders. Hence, it was resubmitted with the EMD. So he even sought the waiver of the EMD. So in IA number so and so, the tribunal permitted Rajesh Kumar Demani, the applicant therein, to deposit the EMD. Since he was a promoter of MSME, it was asserted that he was given an assurance that his plan would be considered by the COC afresh, as his plan value was higher than the plan value of SFPL or other things. The tribunal permitted the COC to consider all plans on their merits with an open mind while considering the delay of so and so. So this was the direction given. Thereafter, there was the calculation and everything, but this plan was rejected by the COC. It was urged that in terms of the evaluation metric, the score of the PMPL was higher than that of so and so, yet the plan of the PMPL was discarded. Senior learned counsel would further argue that the decision making the process has tilted and to the detriment of the MSME promoter, that this adjudicating authority can always steer the wheel of the commercial wisdom, which if done would clearly manifest the evaluation matrix was thrown to the winds and the Swiss challenge method was abandoned and the MSME promoter was left in the lurch. It was not provided a negotiating platform. It was deprived of the chance of improving the plant. Hence, the act of the COC was against the commercial wisdom. So this was the contention of the promoters. So the opposite contention was, it was argued that was feasible and not viable since it does not disclose the source of the fund, provided nil payment to the operational calendar, yet it was passed without giving MSME promoter a level playing field. Ultimately, after going through various judgments, they have come to the conclusion in paragraph 18 that we have noted that the COC has discussed and deliberated upon the plan of the MSME promoter at length and found plan it is not feasible and viable due to the reasons mentioned in the minutes of meeting and extracted above. It is almost tried and settled law that the commercial wisdom of the COC cannot be called in question unless there is a glaring omissions and deficiencies are stark. In view of the fact that the COC is of the opinion that the plan in fact does not deal with the source of the fund and is based on the contingencies which in fact evident from the records, we find no reason to interfere. So no equities have been created by virtue of section 240A in the favor of promoters that their plan has to be considered. Over and above that, COC can still reject it. Even if it is approved and they make a default, the company will be taken to the liquidation and there will be no recourse further. So far, I think I have covered most of the thing I wanted to cover for this presentation. And now I request all of you to ask if any of the questions you have, which you could not ask, what you want to ask, or you just want to enlighten me what your thoughts are on the topic. So there are 30 participants, no questions. Pramod is smiling, sir, you have troubled me enough. I don't want to, I don't want to agonize myself more.
Sir, in fact, I have troubled you more.
No, it's always a pleasure to have an interaction. All of you are seasoned professionals in your respective fields. Any question, Abhijit ji?
No, sir. I'm, more or less, I would like to listen more and understand more. So that is why I'm just, silently listening on this particular aspect. It's very new for me. This entire, line of, what topic. So that is the reason why I'm just listening right now.
Thank you, sir. So if you have any question, feel free to ask here or after this presentation. And
Could you please share your number, sir?
yes, I'll share it in the chat box.
Okay.
And so, yes. After the presentation, they will also share the relevant judgment and etc. They always ask us, and they will reach to you, so you can go through them if you have any further questions. So most all other persons are invisible. Abhijit ji, Jain Saab, any questions? Ashok ji?
No, sir. No, sir. It was a wonderful presentation, by the way.
Thank you. Thank you. Like if there are few faces available and they are smiling, it is worth making it. Gaurav ji, Ashok ji, any questions, comments?
So this topic was nicely covered and was very enlightening.
No, sir. Good.
Thank you, sir. Thank you. So if there are no questions, I'll request. Thank you, Mamta ji. We always listen your lectures, but so they are always nice. I'll request the organizer if we can close this meeting.
Thank you very much, sir, for such a nice presentation. Thank you very much for taking out time and giving such a nice session. Sir, you are requested to please share PPT with us.
Sure,
So that we
Yes, sir. Please do that.
Thank you, sir.
Thank you, sir. Thank you very much.
Thank you very much.